clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors are here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors, and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stock repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. You are welcome to Heritage TV, hanging out with Vicky. And this afternoon, I have with me a seasoned solicitor and a partner at BWF Solicitors, who will be discussing with us children applying under the 7-year rule for leave to remain with their parents. I would like to acknowledge our sponsors, BWF Solicitors, Victon Estates, and Eagle Heights International School. If you want to contribute to the program or send in your questions, you can do so on our Facebook at Heritage TV or on BWF Solicitors Facebook. They are also streaming live. If you want to call us live during the program, the number is 0744-8619-711. The number again is 0744-8619-711. May I also remind you that BWF Solicitors has won so many awards for all their good work and the high rate of the successful high rate of applications that they do on behalf of their clients, and they specialize in civil litigation, family law, immigration, and nationality. So if you have any issues with family law, litigations, or immigration and nationality, look no further. Contact BWF Solicitors. Their details will be announced at the end of this program. Let me quickly introduce our guest, Lawyer Eunice Achampong. You are welcome to today's program, the Legal Hour Show.
Thank you so much, Vicky. Hope your week has been good.
Right. Hi. Yes, it has been very, very, very good. The weather has been a bit, funny, but I believe that probably towards, around 2-3 o'clock, we are hoping we'll see
it
the
will
sunshine.
brighten up. Yes, at least this whole week has been sunny. So I'm hoping that today will brighten up later on, because we have Ghana party in the park as well. So hopefully things just turn out good.
Yes. We'll talk about it later on at the end of the program. I'm going to be there as well.
That's good.
I believe BWF Solicitors will have a stand there.
Yes.
And they'll be having their community and a law program there. So I would love to, coming along.
Yes, definitely. Definitely. At least I'm wearing a t-shirt that brightens us up as well.
Oh, wow. Okay. Is that BWF t-shirt?
Yes. But I was even talking about the color, the fact that the color is brightening us up, even though we don't have a sunny weather today.
So it will complement. That's a nice one.
Yes.
That's a nice one. Right, it is. Any update before we go into today's topic?
Yes.
As we always do every week.
So just to say hello to our viewers, those watching us on Facebook, YouTube, and any social media handle that we may be watching it from and around the world. So very good afternoon to all of you. And also just to give us a bit of an update on the law. Just before I came on the program, I was just looking at those who currently are living in the UK and for one reason or the other have still not been able to return to their country of origin, and they have visit visas up until the 30th of September, or visas that are due to expire before the 30th of September. So if for any reason you have not been able to return to your country of origin because you are ill, because of the fact that maybe your borders have some restrictions, the CIH assurance team is saying that you can ask for an extension or you can ask for assurance of your leave from now up to the 30th of September 2021. So that should help in terms of those who are seeking to remain in the UK and to do a switch. So for instance, you have parents here and you want to make an application for leave to remain, or you have a spouse, or for one reason or the other, you want to switch to the student route or the work permit route, you can do so even now. And so obviously those who are able to ask for the assurance, you can email cihassurance@homeoffice.gov.uk for them to extend your, leave from now up to the 30th of September 2021. And also in terms of those who may want to make indefinite leave to remain applications. We have this recent case called RV Monga, and in terms of, for instance, those who came here on, let's say, student visas and have had to extend or switch from those routes to other routes, at least they have said in that case that if you were on a visit visa and you return to your country of origin to make an application, and then came back to the UK with a valid visa, that visa that you first came with can count towards your 10 years continuous residence in the UK. So usually if you're able to show that you have continuous legal continuous residence for that 10-year period, you should be able to make an application for indefinite leave under our immigration rules. And so if for one reason or the other, you had a visit visa, you had to return and then come back, as long as that, that leave that you had outside of the country was not more than 6 months, that can count towards your indefinite leave to remain application. So most of the time, they would say in the immigration rules that you shouldn't be absent from the UK for a period of 6 months or more. And so in each given year, you should be able to show that you were in the UK for a period of more than 6 months. I will put it that way. And so in this case, of course, once the applicant was able to show that he went back to his country of origin and within a month returned with a student visa, they counted his visit throughout the UK. So if he had stayed for 2 months and then went back to his country of origin and returned within a month, that whole period was counted towards his 10 years continuous residence, which was brilliant because usually they would count the leave that you entered with maybe as a work permit visa holder, or a student visa holder, or a family permit visa holder towards your indefinite leave to remain. But in terms of this case, we were so excited to see that this person who had a visit visa could use that as a way of counting towards that indefinite leave to remain continuous residence. So yes, this is just a bit of an update in terms of our immigration rules.
Right. Great. Lawyer Eunice, today's topic, children applying under the 7-year rule. 7-year rule, right?
Yes.
To remain with their parents. Before we talk about this, is it different from the 10-year rule? Have they got 7 and 10?
So yes, when you
I'm getting a bit confused there.
So when you look at our immigration rules, especially under Appendix FM, it says that if an applicant was to make an application as a parent, they will be making the application based on a child who is British, or who is settled, or who has lived in the UK continuously for a period of at least 7 years. So in our immigration rules, there is that category of children that can be relied upon. And when you look at our British Nationality Act of 1981, it says that under section 1.4, that if a child can show that they have lived in the UK for the first 10 years of their life, they can register as British. And so once a child turns 10, they can then make an application to register as a British citizen. So, of course, once a child becomes a British citizen, they have all the rights just like any other British citizen. And then you have a child who has lived here continuously for 7 years. And based on case law, if a child has lived in a country for 7 years, then it means that they've established that place as their permanent home. They've built deep roots, cultural ties, social ties that cannot be severed. And so once a child has gotten, should I say, used to a place, it is very difficult for them to, should I say, separate themselves from the relationships and the community in which they have built those ties. And so there is the 7-year rule, and then there's the child who is 10 and can register as British. Yeah.
Okay. So today we're focusing on a child applying under the 7-year rule for leave to remain with their parents.
Yes.
Okay. All right. So please take us through.
Okay. So when you talk about a child who is on that 7-year rule, you look at our Immigration Act, and it talks so much about the family life, but it also talks about private life. And we all know that we have that right enshrined in our British laws. And so even though the European Convention of Human Rights establishes a lot of our human rights that we use here in the UK, we also have it enshrined in our immigration rules and in other parts of our law. And so when you look directly at our immigration rules, we have Article 8, which is the right to private and family life. And of course, when you say somebody has private and family life, it means that that person has established certain ties that they believe that should not be severed or cannot easily be severed. And so when somebody has formed those ties, it's very difficult to say that that person has not made that place a place that they can call their home. And when you look specifically at our immigration rules at paragraph 276 ADE, it talks about private life. And when you look at private life specifically, it says that, of course, that if a person is making this application on the grounds of private life, that at the date of the application, that applicant should be able to show that they have lived here continuously for a period of at least 7 years. And that is just one of the strands under paragraph 276 ADE. And you have other strands that talk about having to show that you have lived here continuously for 20 years if you are above the age of 18. And then those who are able to show that maybe they are above the age of 18 but under the age of 25 but have lived here for more than half of their life can also make an application based on their private life. And so, of course, we have all these strands, but today we're focusing mainly on a child who is under the age of 18 and has lived in the UK continuously for a period of 7 years and would want to make an application for leave to remain in the UK.
Okay. Right. So that leads me to my next question. What are the requirements for the 7-year rule and immigration rules?
So in terms of the requirements, you have to be able to show, or the person who is the applicant has to be able to show that they have, at the date of the application, lived in the UK for a continuous period of at least 7 years. They should also be under the age of 18, and they should be able to show that it will be unreasonable for them to leave the UK. So you have a person who is under the age of 18, you should be able to show you've lived continuously in the UK for a period of at least 7 years. And then you should be able to show that it will be unreasonable for you to leave the UK. And so when we talk about these three different strands, then you ask the question, how are you able to show that you can meet all of these requirements? Of course, if you have your birth certificate, you can show that you are still under the age of 18. And your passport will also show your your birth date as well. So that can also help in terms of showing that you are at least under the age of 18. And then in terms of showing that you have lived here continuously for a period of 7 years. So it could be a child who was born in the UK, or it could be a child who was born outside of the UK. As long as they are able to show that they have lived here for a period of at least 7 years. And so that means that if you are going to show a caseworker who is deciding your case that you've lived here continuously for 7 years, you have to provide evidence in terms of school letters, it could be GP letters, it could be any form of proof of address to show that you have indeed lived in the UK for that period of time. So that will cover that section of the requirement. And then in terms of showing that it will be unreasonable, of course, that would mean that you now have to show that you have established those deep roots, those social ties with your friends at school, with your church mates, with the community, their after school clubs. So I know children that go to after school clubs as well will be able to show that they have different activities that they are involved in. Of course, if you are somebody who is very good at school and you want to show off how academically brilliant you are and how your teachers love you, you can go on and do that as well. And then there are those that are good with other things outside of school. So it could be a sport, it could be learning an instrument, whatever that child is good at, you might as well show it. And then, of course, if you have friends and you like to organize things with your friends, of course, you can also, tell your friends that, hey, I want you to write me a letter to say how much involved I am in your life. And sometimes all these things come together and they help establish the social ties that that child has formed, and also the cultural ties as well, because of course this is the only home they may now know. And if they came to this country when they were very young, they've really and truly forgotten what life was like back in their home. And so of course they now see the UK as their permanent home. And why not? Because of course they've lived here longer than they have lived in the country that they were from. So it does make sense to be able to help show all of these things when making the application.
No, Eunice, you see, what you made mention that the child should be living continuously in this country for 7 years. Now, we have certain parents who take their children abroad for a while. The reason why I'm asking this question is, how long can a child live outside the country? Because you said the child has to continuously live in the country. So let's take it that the child is taken outside the country to be with relatives for probably 6 months to a year. Child comes back, then probably summertime goes back again for another 4 to 8 weeks, comes back again. I need a clarification what continuous stay in the country and how long can you live outside the country to qualify for this application?
So if you look at our paragraph 276B, it defines what continuous residence is. So continuous residence is having to show that you have lived here legally, or you have lived here continuously without any break in your residence here in the UK. And then if you go on further, it talks about the fact that you should then be able to show that you haven't been absent for a period of 6 months or more. So if you haven't been absent for a period of 6 months or more in a 12-month period, then of course your continuous residence will not be broken. So if you are then saying that you've lived outside of the UK for a period of 12 months, then it means that your continuous residence has been broken, and therefore it will start again at the time in which you last came to the UK. So if, for instance, you went to live in Sierra Leone in 2010, and then you came back sometime in 2015, and then you want to be able to show that you have lived here for a 7-year period, it will be difficult to show that now because you last came back in 2015. And so therefore your 7 years will start from 2015 and not from 2010. And so once you are able to show and accumulate the fact that you have continuously lived in the UK for that period of 7 years, then you can put in the application to say that you've also formed your private life here in the UK. And it's interesting because we can't mix private life with family life. As much as they are intertwined, you have to also learn to separate the two. And the recent case law of NA Bangladesh makes you understand why those strands should be separated rather than just looking at the fact that maybe a child has formed family life and that is it. And so, yes, there's private life, and then there's also that family life that a child would have formed whilst being in the UK.
Okay, all right. Who is a qualifying child and the reasonableness test following the case of NA?
So when you talk about a qualifying child, you have our Nationality and Immigration and Asylum Act defining who that qualifying child is. And I know that our immigration rules keep changing and the law keeps changing as to who a qualifying child is. But if I were to strictly go by what is in our Nationality and Immigration and Asylum Act, that qualifying child under Section 117B will be a child who is British, or a child who can show that they've lived in the UK continuously for a period of 7 years. And then you also have a child who is settled, or a child who has indefinite leave to remain. And then also currently under our immigration rules, a child who has leave to remain under the EU settlement scheme. So, of course, if you are able to show that this child has lived here continuously for a period of 7 years, that child is a qualifying child. And therefore, it makes it easier for a parent to show that it is in the public's best interest not to remove that parent from the country if they are making an application based on this child. And they can also show that they haven't got any, should I say, deportation order. So a deportation order is usually in relation to a parent who has committed a crime for which they have been sentenced to a period of 12 months or more. So usually that will be a case where somebody will be given a deportation order. Otherwise, if there hasn't been any deportation order in relation to that parent, then it is said under the law that there is a public interest to remove that person from the United Kingdom if they can show that they have a genuine and subsistent relationship with that child who is at least 7 years old or has lived in this country continuously for a period of at least 7 years. So that helps in terms of those parents who would want to make an application. And then in terms of the reasonable test, obviously there have been so many case laws in terms of why we say it would be unreasonable for such a child to return to their country of origin or to return to the country where their parents are from. And we've had cases go up even to the Supreme Court. So you have cases like KO Nigeria, that was in 2018, that spoke about the fact that when a child has lived here continuously for that period of 7 years, it will be unreasonable to obviously send that child back to their country in which the parents are from, or their country of origin, if for one or many factors we can show that obviously the parents may have breached immigration rules. They have done A, B, and C in terms of breaching the laws of the land. But if we look clearly at the child and the child's best interest, then of course it should be that the child would remain in the United Kingdom, or it would be unreasonable for that child to leave the United Kingdom based on the factors which show that this child has obviously built their home here in the UK. And you have other cases, before KO Nigeria, which talk about the fact that every case is a case-by-case scenario. So you have to look at the facts of every case. And one of those cases is EV Philippines, that talks about the fact that a child's best interest is to look at the social ties that this child has built here in the UK. You need to be able to look circumstantially at what the child's private life is. And so if you are looking at the circumstances of each case, then if the child has formed their private life outside of their family, which is they have friends at school, they are in the education system, they are doing well at school, they have extracurricular activities that they do, maybe they are inviting friends over for sleepovers, maybe there are children that will go out to school programs and school outings, and they help their teachers with whatever their teachers need to do. So all these things count towards a child's private life. And so I know a lot of children who definitely are active at school or are active outside of the home. So apart from being at home with their mom and dad or with their siblings, they have very active lives outside of the home. And so when you're looking at a child's private life, you should consider all of these other factors that make the child who the child is. And so it makes sense to be able to get some form of evidence to show that these other factors are important in the child's life, and they cannot easily be severed or they cannot easily be broken, because the child does not know any other home apart from the UK. And maybe they are so enshrined in the education system and they have so many other commitments outside of the home that it will be difficult for them to start all over again in another country where they are not used to. And so it makes sense to get as much evidence to show that this child has formed that private life outside of the home or outside of their family. Of course, when you say a child has lived here continuously for 7 years, it could be a child who's above the age of 7, because I'm talking about a child who may not have necessarily been born here in the UK. But if it's a child who was born here in the UK, then of course, once that child reaches the age of 7, there's so many things that you can say that this child does outside of the home. And if they even have siblings, I'm sure their siblings will be able to testify that they do things at school, or they do things outside with their friends and the rest of it. So all these things count towards the different factors when a caseworker is looking at a child who has formed private life. And they are always going to consider the child's best interest, because it's one of the obligations under Section 55 that they have to consider what the child's best interest is. And if it is in the child's best interest to continue to remain in the UK, then of course that would be unreasonable for them to then say that the child has to leave the UK.
Okay. Now, Eunice, I'm just sitting down thinking maybe someone might have a child who is not 7, but might be either 8 or 9. Can such a person qualify under this? Or the child has to be exactly 7 to qualify?
No, so that's why I was saying the child has to be at least 7. So, of course, if that child is 8, 9, 10, 11, 12, 13, then they are over and above that, should I say, threshold. And so the threshold is they have to have lived here continuously for at least 7 years. So when the child is 7, then you can think about making the application for that child. Yes.
Oh, okay. All right. Ladies and gentlemen, if you've just joined us, this is Heritage TV hanging out with Vicky. And today we are discussing about immigration. The topic is a child applying under the 7-year rule for leave to remain with the parents. And with me is lawyer Eunice Achampong from BWF Solicitors. She's a solicitor and also a partner at BWF Solicitors. If you want to contribute to this program, you can do so live on our Facebook pages, either Heritage TV Facebook page or BWF Solicitors Facebook page, where we are, broadcasting live. If you want to call us live on the program, the number is 0744 8619 711. The number is 0744 8619 711. Lioness.
Hi.
Right. I've got a question here. The person is asking, can I put in an application just before my child has lived here for 7 years?
Okay, so usually that would be a no-no, because when you look clearly at paragraph 276, it says clearly that the requirements for making an application for leave to remain based on your private life is that at the date of the application. So it has to be at the date of the application the applicant should be able to show that they've lived here continuously for a period of at least 7 years. So if you haven't lived here continuously for at least 7 years, then of course that would mean that you haven't really met the requirement. And so you don't want the application to be refused just because when you were making the application, the child hadn't lived here continuously for 7 years. And so it's even more important that you are able to show that 7-year period in the documents that you are even going to be bringing. So as much as possible, if you are saying that you're making an application for this child, to show that as much as possible they've lived here for a continuous period of 7 years, then when you're making the application, that evidence should also be provided. It can't be less than the 7 years. It has to be continuously for that 7-year period. Some people will say, oh, but once the application goes, the child would have attained that 7-year period and they'll still be making a decision. No, it's very strict in the way it's been worded in our immigration rules. So it has to be at the date of the application. So that person should be able to show clearly that they meet that requirement, and the evidence should support the fact that they are able to show that they've also lived here for that continuous period of 7 years.
Okay. All right. Okay. I've got another question. This person wants to remain anonymous. The question is, my partner and I put in an application when our daughter turned 7 years old. We have 2 other children who are part of the application. We were granted a fee waiver, which we used for the application. When we went to enroll our biometrics, we didn't have much supporting documents, apart from my wife and our passports, the children's birth certificates, and a letter from their school confirming the role they play in their school life. Is there anything else we could have included?
So yes, I think that definitely they could have included more supporting documents in terms of this application.
Okay.
So it's good that they made a fee waiver application, because in most instances, people who are making this application with a child who has lived here for that continuous period usually would not be working because they are not allowed to do so. And they would usually have people supporting them in terms of the finances and maintenance and the rest of it. And so if you are able to apply for a fee waiver and you are granted a fee waiver, that is absolutely brilliant, because then it means that you don't have to worry about paying $2,612 for each applicant as the fees currently stand for application and the IHS. So that's a brilliant thing in terms of the fee waiver application. But in terms of making the application for leave to remain, we see that, of course, the child themselves, in making that application, is making the application based on their private life. So the applicant, who is the child, has to be seen as an individual separate from the parents.
Yeah.
And so once that child has reached that continuous residence of at least 7 years, they should include the evidence that shows that they formed that private life. And so if, like I was mentioning before, they are able to show that they have extracurricular activities that they are involved in, they obviously probably do well at school, they can show, of course, that they have other activities that they do with their friends, any letters from those extracurricular clubs or their sports club or the music clubs or even the after school clubs, and even school, the school itself, if they are academically brilliant and they want to add certificates of awards that they have gotten and achieved and the rest of it, they can do so. And letters from their friends to show how much their friends love them and will miss them. they can definitely add all of those things as well to show how much integrated they are within the British society. And some of us will also have different religious groups, whether it's the church or whether it's the mosque or whatever it is. You can also show that, of course, your child is involved in that religious setting as well. And then for some children as well, they may have certain medical conditions for which they will be receiving treatment here in the UK. So you have children with special needs, they may even have learning difficulties and they are receiving support. And you're saying that that support will be very difficult to get in that country where the parents are from. Or you are saying that that medical condition is one that the child is receiving treatment here, and maybe it might be very expensive in the country where the parents are from. And so you are showing as much as possible that all these things that the child receives here in the UK is important or is key to their survival, and therefore it will be much more difficult for that child to go and live in the country where their parents are from if they would not have the same support, or the treatment that they will be getting will be more expensive in the country that they will be going to. So there is so much more evidence that you can, include in such an application. And for the parents, of course, they are making the application dependent on this child. And so if that child's application under paragraph 276 is successful, then of course they will grant the parents further leave to remain based on the fact that they are parents who have a genuine and subsisting relationship with this child. And this child has clearly shown that it will be unreasonable for them to remove him from this country. And therefore, the parents can rely on this parental relationship that they have with the child to be able to also get their further leave to remain. And of course, when you look at our immigration rules, it's very broad in terms of showing how that child is able to say basically that they have a genuine and subsisting relationship with their parents. So if the parent can get letters from the school and from GP to show that, of course, we are involved in our child's life. We take the child to school, we go for parents' evening, we take them for medical appointments, and the rest of it, that in itself should be able to show that they are involved in that child's life. And it goes a long way to also meet the requirements of the parents under Appendix FM of the immigration rules as well. And of course, if you're a parent and you are saying that the child lives with you, different letters will definitely show proof of address that you as a parent are also living with the child. And so it's not like a distant relationship. And even if, of course, you don't have those letters readily available, you can always ask for those letters, or you can always ask for your solicitor to request those letters on your behalf, so that as much as possible, they can see the ties that the child has with yourself, and then grant you further leave to remain under Appendix FM of the immigration rules. So it's very open, and I think that the Home Office are very flexible in their approach when they are looking at such applications as well.
Okay, all right, okay. I've got another question just coming. It's from Sarah. What are the chances of the application being successful if the child has lived here for a continuous period of 7 years compared to a child who is British?
So I think this is one of the questions that you were asking at the beginning. So what is the difference? So if my child has lived here continuously for 7 years and I'm making the application, most people will try and say, do I have to wait until my child is British before I make the application? Or can I make the application now that I can show that my child has lived here for at least 7 years? Of course, just with any application, you don't have 100% guarantee. But because we have our Home Office guidance, we have case laws, and we are able to show under our immigration rules that this child has reached that age where they can show that they've lived here continuously for that 7-year period. We are able to show that as much as possible, based on the case laws that are now readily available, a child who has basically lived in this country for that period of 7 years has formed deep social ties, has formed deep cultural ties. That child has formed ties that cannot easily be severed because they have friends, they have activities that they are involved with. Maybe the only language that they know how to speak is English now, because even if their parents speak the local dialect with them, they don't want to speak. They always want to speak in English. And so all of these things go towards the fact that this child views the UK as their permanent home, and there isn't any other place they would want to go. And so if there is evidence from all these strands of places where this child is able to show that they have built those ties, then that could be included as part of showing that this child has formed a private life here in the UK. And you have our Home Office guidance, which is able to help in terms of showing that as much as possible, that child has also built private life here in the UK. And when you are talking about the Home Office guidance, it also shows that flexible approach in the fact that they will be able to look at that application if they are able to consider the different factors in terms of showing the child's best interest, and then also the fact that the child can also show that as much as possible, because they've also built other ties with the community, with their friends at school and the rest of it, they are, of course, showing that they have formed private life, and therefore it will be harsh for the Home Office to refuse their application. And yes, of course, if they are showing that their family has also lived here for quite some time, and most of the time, I'm sure that the parents would have also lived here longer than the child has. And so, of course, they formed a relationship with their family. And if they have extended family here in the UK, you can also include them as well as them having formed a relationship with other members of their extended family. So maybe they have grandparents, they have uncles, aunties, and the rest of it. Then you include that as well to show that they've also formed ties with extended family members who live here in the UK, and therefore they have nothing to go back to in their country of origin, and therefore this is their permanent home. And so if you are able to show that, it will be very unreasonable and it will be harsh as well. Of course, the Home Office will consider all of the evidence that you put forward and will make a decision in terms of them meeting the requirements and the parents also meeting the requirements under Appendix FM of the immigration rules. So yes, you can still make the application. It is not 100% guarantee, but at least it offers you a chance to have your leave to remain earlier than waiting for the child to turn 10. Usually, of course, when a child turns 10, you can register them as British and then make the application, which a lot of people would then do, because once a child is British, they are entitled to remain here in the UK because they are British and they have the rights to all the other things that a British citizen will be involved in, such as free education, free healthcare, and the rest of it. So, yes, there is some, should I say, probability in the application being done when the child is registered as British, but you can also make the application once the child has been able to show that they've lived here for that continuous period of 7 years. with all these other case law to also back you up. But that means, of course, you should be able to show the child's private life here in the UK aside from their family life.
Okay. All right. Someone is just sending me a funny comment asking what is the success rate with this application?
So of course, there are people who have made these applications in the past and they will tell you, I was refused because of this, and that. But now that we have the Supreme Court case of KO Nigeria, and even in this current case of NA Bangladesh, where it says that you should be able to, of course, show that this child has formed their private life aside from their family life here in the UK. As long as you are able to show these different factors, the application should be successful, because I know people who don't even have what do you call it, a child who is British, and they've made the application because their child was 8 or 9, and of course they were able to show the involvement of that child in school and at church and at different organizations or different extracurricular activities that they do, and they have been granted further leave to remain. So it is, I'm not going to say it's 100%, because of course, if you are not able to show clearly that this child has formed a private life outside of their family life, then you may not be satisfying the requirement to show that they have formed a private life here, which will make it unreasonable for them to leave the UK. So yes, they can be successful, because I've had successful cases. And then I know with those that have British children, they will tell you that almost always they are granted leave to remain. So yes, it all depends on the evidence that you provide.
Oh, okay. All right.
Yeah.
So it all depends on the evidence. Yeah. So if one applies for the child at 7 or 8 or 9, proving that they've continuously lived in this country, after being given indefinite leave to remain, when does the child apply for naturalization to become a British citizen? Let's say if a child is 9,
yes,
applies and given indefinite leave to remain, turns 10, can the child, apply for naturalization and British citizenship?
So if, for instance, the child turns 9 at the time they were granted leave to remain, as much as the child is saying that they now have leave to remain, they don't have to wait for the leave to remain to expire before they register as British.
Right.
So as soon as they turn 10, they should be able to gather evidence to show that they've lived in the UK for the first 10 years of their lives. And so if they're able to gather evidence to show they've lived here for that first 10 years of their life, then they should be able to make the application to register as British. They don't necessarily have to wait for the leave to expire. Yeah. I think that there's also a question that came up on our platform.
Right. Because I think I'm done with mine.
Okay. What does it say? It says, what comes next after a 10-year further leave to remain? Is it indefinite leave or citizenship? So once you've completed the 10-year route to leave to remain, so usually it's either the parent route or the partner route. So if you're on the parent route and you are relying on the child, once you've completed that 10-year period, you should then be able to make an application for indefinite leave to remain. So you don't jump from leave to remain to citizenship. You have to make an application for indefinite leave to remain, which means that there are no restrictions on your leave here in the UK. And so once you've made an application for indefinite leave to remain, then you should be able to make an application for citizenship at least 12 months after you have been granted indefinite leave to remain in the UK. That was Mr. Micah Hammond. I don't know if we have a bit of time. I'm just looking at other questions.
So, ladies and gentlemen, as we are waiting for Lawyer Eunice, this is the Legal Hour Show with BWF Solicitors. And we have with us Lawyer Eunice Achampong, a seasoned solicitor and also a partner at BWF Solicitors. And we've been discussing children applying under the 7-year rule for leave to remain with their parents. And she was taking us through the process, the requirements. We also discussed a few questions on whether we should definitely apply when the child is 7. She made mention that it doesn't matter. You can apply for the child from the age 7 and above. All you have to do is to show evidence that the child has continuously lived in the UK. Laura Eunice, are you ready for us?
Yes.
If you don't have any further questions to discuss with us, I think we can round up and, tell us your details for those who would like to get in touch with you after the program.
So as we've mentioned, I know there will be people who may be in this current situation, but apart from dealing with immigration issues, we at BWF Solicitors also deal with other areas of law, which include family law, and then, of course, if there are any civil litigation issues or resolution issues that in terms of dispute resolutions, we also deal with them as well. So if you have any issues and you would like to make inquiries or you would like us to assist you in any cases that you may have, please do not hesitate to contact us on 0208 493 7340. I'll take that again. It's 0208 493 7340. And our offices are situated in London. The address is the 4th floor of Anna House, 214 to 218 Tottenham High Road, London, N154NP. So it's N154NP. And we are open from Monday to Friday, from 9:30 a.m. to 6 p.m. in the evening. And so, of course, now that we have most of the restrictions lifted, we are trying as much as possible to keep with the hand washing, the hand sanitizing, and the face mask. I mean, those restrictions have been made lenient, but we are still keeping to them as much as possible, as the COVID is not gone yet. And so we are trying to protect our clients, and for our clients to protect us, we want the guidelines that have been put in place to continue in our offices. So thank you so much, Vicky. And I know hopefully in the afternoon, you'll be showing yourself.
Yeah, that's what I was going to tell us a little bit more about this. The Community and the Law program by BW. I think it's a different location today.
Yes. So our weekly program, which is the Community and the Law, on Saturdays from 4 p.m. to 6 p.m. Will be held slightly earlier today. And we are doing it live at the Ghana Party in the Park, which is going to be at Cockfosters. And so I think that most people who would be going to this event this afternoon will see our live stand there. We will be doing a lot of, canvassing. And so anybody that does come around, we will basically be informing them of what we do and of course how we can assist them. And if people want to have one-to-one consultations, they can do so in our tent even before the live program goes on. And so we would be trying as much as possible to do a lot of outreach during today's Ghana party in the park. So it should go well. I'm looking forward to how everything will pan out at the event. So this is the first time we're having to do it outside of the studio, so it should be all fun and well, and it's a good way to commemorate the fact that we've turned 15 years, so doing this outside of outside of the studio or outside of the office is a good thing. So yeah, it's just to also reach out to our community, just as we say we are community lawyers.
And I think if going to be at the Ghana party in the park and want to see the team live and personally, then you see them at their stand, at the Ghana party in the park. Usually people see you guys, at the radio, social media platforms, but I believe that lots of people are yearning to meet you guys face to face. So this is the only opportunity for people to get to, interact, have that personal touch with the team at BWF Solicitors. Yes, we will be there as well to support. So, ladies and gentlemen, on that note, we hope to see you at Cockfosters at the Ghana party in the park for part 2 of the legal education. Let me take this opportunity to say thank you so much to BWF Solicitors for sponsoring this program. Also to Victim Estates Limited, your property company, Eagle Heights International School, which is an extra tuition center specializing in maths and English. Thank you so much for making it possible for us to, come your way today. Hopefully next week, same time, we will come in your way with another interesting topic. So I hope you have a lovely weekend. Take good care of yourselves and see you probably later on today at the Ghana party in the park. Take care. Bye-bye.
Listening ear and sympathetic view. Thousands of people all across the UK in all areas of personal importance. We have received great feedback reviews from our clients. We are located at Solicitors in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors are here to help you with your legal services when you need us.